All right, hello and welcome to this Evidence Law Capsule. Today I'm going to be discussing a bit of a complex rule, the Co-Conspirators Exception to the Hearsay Rule. It is not a rule that is taught in any great length in most evidence courses, but it's one that's well worth knowing about. So I'm going to try and give you a basic overview of some of the ins and outs of this particular hearsay exception. So the best way to start thinking about this particular exception is actually, believe it or not, by thinking about another exception. In this case, the admissions exception to the hearsay rule. Because once you understand how that exception works, and if you haven't seen my other capsule on the admissions exception, it might be worth looking at that first. But it helps you understand the way the co-conspirators exception is so special and so different from the way in which we admit most types of hearsay. So this is going to be a hearsay exception. I don't want to go into the definition of hearsay. Everything that I am admitting here I am using for the purposes of the truth of the contents of the statement. So let's just get through that right away. We're looking at exceptions. So here's what we've got. We've got our witness who's in court today. That's Bob, and this is what he's testifying to. I heard Johnny say, Sherry and I are robbing that bank. So there's the statement. You want to use it to charge him with robbery. It shows identity. It's useful for a bunch of different things. So there's your witness. Obviously, these two parties are both accused at the trial, so you can't call them. But the admissions exception allows you to use this particular statement here, but only in a very specific way. So any admission by a party, which means any statement by a party who's adverse in interest, and the Crown is obviously prosecuting, is admissible against the maker. And the reason for that, I won't dig into the admission exception in depth, but it has to do with fairness. Effectively, the idea is that Johnny cannot complain about an inability to cross-examine, which is the core of the hearsay rule, when he himself is the maker of the statement. It would be ludicrous to say, well, I can't cross-examine myself. So therefore, the statement is admissible against Johnny. But it's equally clear that the statement is inadmissible against Sherry. You can't use it in that way. And the reason for that is, once again, fairness. Sherry has a legitimate complaint that she cannot cross-examine the maker of the statement, who is Johnny, and therefore the admissions exception to the hearsay rule limits use of any admission against the maker of that statement. So if this is all the Crown has in a particular case, the Crown can use this statement and maybe get a conviction against Johnny, but they will not be able to use it, and if it's admitted, it will come with a very important caution to the jury or the judge saying you cannot use this statement against Sherry. Now, how does the co-conspirators exception relate to this? Very simple. To cut right to the chase, when you can satisfy the requirements of the co-conspirators exception, this statement is admissible against Johnny, but it's also admissible against Sherry, and that's very important. So you've got a robbery case and you want to prove that they're both guilty. Again, I'm going to go through the requirements, which are quite stringent, but if you can meet them, Johnny's statement can be applied as guilt for Sherry as well as Johnny. It can go to show that they were both involved in robbing the bank. And that's a very, very powerful tool for the prosecution. So you have to understand the difference between the admissions exception, which is limited to the maker of the statement. Co-conspirators exception can be applied to any member of the conspiracy. That's really important. So I've only got two people here, but theoretically conspiracies, which are, I'm going to talk about what they are in greater detail, are big joint agreements, could have multiple parties. And if you can prove that party A, B, C, you can admit Johnny's statement against Sherry, A, B, and C, as if they made that statement themselves. Very, very important. And I'll just say, what you should all be knowing already, but just as a reminder, admissibility is just admissibility. Obviously, this statement does not prove that Sherry robbed the bank or any of these other parties, A, B, and C, did either. I'm just talking about, is the statement admissible? As an admission, it is not admissible against Sherry, but as a co-conspirators statement, it is. Now let's talk about what that means in more depth. So here are the basics. The first is, this is essentially, in a nutshell, the basics of what the rule is. Anything said or done by one conspirator, so you have conspirators, A, B, C, it doesn't matter, and if A says something, X, that statement if it qualifies, is admissible against all makers, as I already showed you. Now, one of the key things to remember, you'll notice the key wording here, acting in pursuance of a conspiracy. That's going to come back in several other elements of this test, but that is key. So there has to be a conspiracy, and the statement said or done has to be done in pursuance of that conspiracy. The co-conspirators exception to the hearsay rule is different than most other hearsay exceptions. Most of them are based on, as I talked about in another capsule, the idea of reliability. Well, reliability is sort of involved, and courts do speak about reliability with co-conspirators exceptions, but, given the fact you have criminals talking about a conspiracy, it's hard to make the reliability case in every case. So really, it's premised on a theory of agency and an admission. Basically the same idea as the admissions exception. The idea of the admissions exception is you can't complain about the inability to cross-examine yourself. Well, the co-conspirators exception is based on agency. You guys are agreed to act together, so you are acting in agency. So even though B didn't make the statement, B cannot complain about the inability to cross-examine A, who is speaking in pursuance of an agreement on B's behalf. So essentially, you attribute B to A's statement through this idea of agency. Now you'll notice I've spoken several times about a conspiracy. There must be a conspiracy. Conspiracies is a legal term, and there's actually got to be proof that a conspiracy existed before this co-conspirators exception can be used. And what that means is there must be an agreement. The key are two keys to a conspiracy. One is an agreement, and the second is that it's an unlawful agreement. That's the key, that you're agreeing to pursue an unlawful object. And I use the term unlawful object because you'll see in a moment, this exception applies to both civil and criminal proceedings. But generally, when you're in a criminal proceeding, which is where this arises most commonly, you're talking about an agreement to pursue some sort of criminal act. There has to be an agreement. The Crown actually has to be able to prove it. And, agreement is taken seriously. You've got to agree to pursue a specific unlawful act or object. It's not enough to say we're going to go get crazy out there, we're going to go do something criminal, we're going to go do something, let's go out and, mess some people up. The less clear it is, the less likely that you have an agreement to pursue a specific unlawful object. And that is really, one of the key aspects of this particular exception. And the nature of the exception itself helps to set up one of its key limitations. The statement has to further the conspiracy. And if you think about it, the whole agency rationale is based on the idea that A and B make an agreement to do something together. And so long as they are acting in furtherance of this agreement, all this time here, we're working to get the agreement done, anything that A says or B says is admissible against both of them. But the moment that the agreement is separated, or the moment that they're doing something that doesn't further the agreement, then the agency rationale no longer applies. If A is not doing something to further what they've agreed upon, how can it be said that B is being represented by what A says? So that's a really important limitation, and I'll talk about this in a moment. I'll show you an example of a situation in which, even though you have two parties talking, the statements are not usable against each other because they're not advancing the conspiracy in any fashion. Two final smaller points to keep in mind. One is it's called the co-conspirators exception, and there's no question that it arises most commonly in conspiracy cases, but it's not restricted. One of the reasons I gave you the example earlier about a robbery, it doesn't matter. This is a rule of evidence. If you can satisfy the co-conspirators exception, you can use it in relation to any case, a murder case, drink driving case. It makes no difference. Any case can be used. The key is you first have to show that there's a conspiracy, and most criminal offending does not involve conspiracies. You don't have a fixed agreement between two or more parties to go out and do something. A lot of criminal offending just happens, much more rapidly or without that type of agreement, or it may be very hard to prove that the agreement took place. For that reason, the exception is a little bit limited, but it's not restricted by law. If you can show there was a conspiracy, you're good to go. And it's not even restricted to criminal cases. You can use it in any civil case as well. Again, the question is, can you show that there was a conspiracy and that two parties agreed to do something unlawful, to advance an unlawful purpose? If you can do that, the co-conspirators exception has been used in civil and even administrative proceedings. As long as you can get through the criteria that are required, there's nothing barring the admission of the evidence. So let me go back to that example I wanted to show you about the difference between in furtherance of a conspiracy and what I like to refer to as the contrary point, which I'll use a different color to illustrate, is about a conspiracy. Okay? Because I can tell you that the essential difference is that where the statement is in furtherance, I guess that should be red, this is admissible, and where it's not in furtherance, you're simply talking about the conspiracy, it's not admissible, because again, the agency rule demands that the parties are acting pursuant to the agreement, and when the agreement is completed, or you're not talking to advance it, then the parties cannot be said to be representing each other. So here's the example. So we've got the co-conspirators exception here. And just to clarify, I don't have the second guy relating it. Let's assume again that we have Bob over here and he's going to testify about what Johnny said, or it's recorded on a wiretap. It doesn't really matter. I need your car so I can go rob that bank. This qualifies, assuming it meets all the things, if you can show the conspiracy in the ways that I suggested earlier. This is a statement that's in furtherance of the conspiracy, so there's no problem here. This statement is admissible against Johnny, and it's also admissible against Sherry. It's made in furtherance of the conspiracy. There's no problem. But let's tweak the facts just a little bit. So here we've got a slightly different statement. Let's assume that it's over and, Johnny goes back to his friend's house and his friend, what's going on? You have my car. I took your car so I could rob that bank. And really, you could make this, it doesn't really matter if it's I or we. So Sherry and I could go rob that bank. It makes no difference whatsoever, okay? Well, in this situation, you've really got a difference in results. Doesn't matter the nature of the statement. The key is that the statement is no longer advancing the conspiracy. And of course, the difference in result is quite substantial. Now you've got a situation where the only way you could admit this is as an admission, not as a co-conspirator statement. So therefore, it's only admissible against Johnny. It's inadmissible against Sherry. So you've really got to watch for that when you're dealing with co-conspirator statements. So let's deal with a few complications involved. I'd say there are two major complications to begin with. This is just to sort of set it up, and then I'll show you how the law has dealt with these complications. Well, if you think about it, we've got a trial for robbery. And essentially, I've just told you that to make use of this exception, the Crown needs to prove there was a conspiracy. And imagine it's a conspiracy trial. Imagine, even that's more even complicated. Imagine you have a conspiracy trial. They're not charged with robbery. They're charged with conspiracy to commit robbery. And you want to admit this evidence, right, from A against B. No problem against A, because A made the statement. But you want to admit it against A. Well, to do that, you've got to show that there was a conspiracy to commit robbery, which is the very charge they're being charged with. You got it? You got to show that there was a conspiracy, and that B was a member of that conspiracy, and you're using the statement for that purpose. That is a complicated little problem, and it's sort of complicated because you're using the rules of evidence in a way that also gets you to the substantive merits of the particular trial. And arguably, it's the judge who admits evidence and says, well, this meets the co-conspirators exception, and therefore I'm admitting it to show there was a conspiracy in this particular case, which is ultimately the jury's role. So there's a bit of complication here because you're trying to do two very similar things. The way chosen to deal with this problem in Canada is a bit complicated. There's something called a Carter application, named after a case called Carter, which is a fairly complex case from 1982, which is designed to resolve the different burdens here in this particular case. So the first thing you do is, assuming you have a valid statement, it's tendered. I mean, the statement is admissible against Jay anyway, against Johnny, so there's no problem there in tendering the statement. And I should just say, this can be a little bit more complicated where the maker of the statement is not a party. if you think about it, then, because it doesn't have to be Johnny, it could be, you can have what's called an unindicted co-conspirator who, I don't know, is dead or has left the jurisdiction or the Crown's not trying them. Let's say party A made this statement, I need your car, but they want to use it against Johnny and Sherry. It's good evidence. In those cases, leaving aside some of the proof issues, which get a little bit more complicated, the court usually still tenders the statement, as long as there might be situations in which the statement is so poor you might have a problem admitting it, but essentially it's tendered anyway, and as you'll see, you have to go through the various burdens to actually show whether it can be used, but usually you can tender it in almost every case. So before the jury can use the statement, the first thing they have to do, according to Carter, is find, beyond a reasonable doubt, that there actually was a conspiracy. If you can't show, if the Crown is unable to show that there was an actual agreement between Sherry and Johnny to actually do this, then there is no agreement. Okay? And if there is no conspiracy, then they can't go any further. There has to be a joint agreement to do this. Now, this is a bit complicated for a number of different reasons, but essentially, to begin with, okay, well, they have to find that there was a conspiracy. One of the difficult questions is, can they use this statement? Sometimes the statement is more detailed. Sometimes the statement is, well, Sherry and I need your car so we can go rob that bank. Can you use that statement? This gets into some pretty complex hearsay questions because you're using hearsay to prove hearsay. Gets a little bit troublesome. I'm going to go with, I believe that the better view is you can use it, because believe it or not, just to show there's a conspiracy, you're not necessarily using the statement for the truth of the contents. You're using it as circumstantial proof that a conspiracy or an agreement between the two parties existed. So, the weight of authority seems to suggest, yes, you can use that statement to show that there was a conspiracy. Next up, the jury must find, on a balance of probabilities, which is the usual admission standard for evidence, that Sherry was part of the conspiracy. And here, of course, you can't use Johnny's statements. That would be really problematic. Johnny would be saying, well, okay, Sherry's part of it, and use of Sherry's name would be essentially designed to link her to the conspiracy, and that would be inappropriate. There's got to be enough evidence of other things, admissible evidence, to show that Sherry was actually part of the conspiracy. If you can do that, the evidence is admitted. At that point, it's usable. And the only part left is you've got to, then go on to conclude that beyond a reasonable doubt that Sherry was part of the conspiracy using the statements, because at that point you're now using it as a matter of guilt. So that's essentially the way it works. It's a pretty complex test. In some other jurisdictions they use a much easier version of this test. Essentially the judge, as they do with all evidence, decides on a balance of probabilities whether Sherry was part of the conspiracy and whether there was a conspiracy. If that's met, the evidence then goes to the jury, and it's up to the jury to decide how to use the particular evidence. So I'm going to briefly go through some criticisms of the rule just so that you have a broader appreciation of how it works and what some of its shortcomings are. But don't assume because I'm doing this that the rule is troublesome or not accepted. It's used all the time. And the reason it's used is because the courts really feel that they need it. There are a lot of situations in which it would be impossible to convict somebody of conspiracy if you couldn't use statements in this way. So this is a very well-entrenched rule that, despite the shortcomings I'm about to show you, is well accepted in Canadian law. And number one, well, we've said before that reliability is at the core of all hearsay exceptions. Not here. This exception is dealing with evidence that's about as unreliable as it gets. You're talking about accused persons who have every incentive to lie or exaggerate in a lot of circumstances. Don't get me wrong, some co-conspirators' statements will have internal reliability, but a lot of them won't, and they get attributed no matter what, automatic. I'll read you a quote from Justice LaBelle, who was dissenting about the admissibility of co-conspirators' evidence in a particular case called Mapara, where he said that the Carter process does not allow the declarant's motive to lie. to be considered. And in any event, you can even show that one conspirator has a strong motive to lie or exaggerate about the other person's involvement. And if you notice from the test, that doesn't matter. If you can show there was a conspiracy, you can show that there was an agreement, the lack of reliability to the statement is not considered in admitting the particular evidence. Justice LaBelle went on to say that members of a criminal conspiracy often have motives to lie. Conspirators may wish to understate their own involvement or emphasize the role of their partners. And, this doesn't seem to matter to the rationale of the rule. Number 2, your head might still be spinning from the way in which the jury is supposed to administer this test with 2 different thresholds of proof. A little bit complex, let's put it mildly. Number 3, it's based on agency theory, the idea that criminals act as agents. I mean, I'm not going to get into the law of agency here, but let's just say the agency standard is pretty fast and loose when you're talking about criminal conspiracies. Try comparing this to agency when you're dealing with admissions, a much tighter standard. And I'm talking about something called vicarious admissions, where you have an employer-employee relationship. Man, the courts insist on a strict standard of agency. Here, you had an agreement, everything you say can be attributed to the other person. That's like a pretty loose theory of agency. Number 4, not only do we ignore reliability, we completely ignore necessity. We don't even, in some cases where you have A and B, like the example I gave you, well, if it's Johnny, and Johnny's on trial, and you have Sherry, well, then that's a situation where necessity is met, because Johnny can't be compelled to testify. But there's no requirement for that. I told you that there's no requirement that the conspirator be on trial. So oftentimes you'll have conspirator C, who's not charged, and the Crown could call them. But the Crown doesn't have to. The rule does not require necessity. In some cases that I don't think are very compelling, but they say, well, the high degree of utility and quality of these statements means we don't even need necessity. So that's good enough. This evidence is so great, we have to admit it. I don't find any of that compelling, but nonetheless, the courts have. And the last concern I'm going to deal with very briefly is civil cases, because as I said, this can come up in civil cases, and the problem with civil cases is that the Carter test just doesn't make any sense. Carter, a real question mark about how it applies, and a few cases have looked at it, and essentially what's happened is they've modified the Carter test, because it makes no sense to talk about beyond a reasonable doubt when you're not protecting a particular accused in a civil proceeding. And this seems to be the framework. I'm not going to tell you this has been fleshed out completely in the courts, but the few courts that have looked at the co-conspirators exception in civil cases have said the following. If you remember number 2, the jury had to find beyond a reasonable doubt that there was a conspiracy. Well, that makes no sense in a civil case. So here what you've got is you have to find on a balance of probabilities there was a conspiracy. Number 3 also gets lessened. This was a balance of probabilities in the criminal context, but courts have found that that's too high given the relaxed standard of admission that takes place in civil cases. So they've got to show some evidence that Sherry was part of the conspiracy, and it's only at the end when you're trying to use them with all the statements together that you've got to find on a balance of probabilities that Sherry was part of it. So there are some tweaks in the civil cases that I think are interesting in the rare occasions where the co-conspirators exception is raised in those forums. And that should give you a good basic primer on the co-conspirators exception. It's a pretty complex rule, certainly in its application, and anyone who's faced with it is going to have to really look at the law in more detail to see how the co-conspirators exception actually gets applied in practice. But I'm hoping this primer will give you at least a good basic understanding of the rule and why it exists, and really some of its shortcomings. A lot of good things you can say, and some not so good things about the co-conspirators exception. In any event, I hope this was useful to you. If it was, let me know. Drop me a line. I appreciate it. In any event, have a great day.
To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.